Your unemployment hearing is the most important step of the unemployment appeal process. In all likelihood, it will be both your best and last chance to obtain your benefits. There is one more appeal step after this hearing, and there is an opportunity to appeal to court. However, those level of appeals are extremely narrow. If you appeal your unemployment claim to a hearing, you will receive a notice that the case has been transferred to the Unemployment Compensation Review Commission, UCRC. This notice contains important information about your hearing, including how to request your file, how to subpoena witnesses and documents, and how to submit documents for the hearing. Requesting your file is critical because it contains everything that has been submitted by both you and your former employer, as well as responses to questionnaires, notes about telephone conversations held with a caseworker, and perhaps more detailed explanation as to why ODJFS is making the decisions that it is. Additionally, the hearing officer will have this file and may refer to it during the hearing, so request your file immediately. Subpoenas can compel witnesses to attend the hearing and can be used to obtain documents from your former employer. They can be requested up to 5 days before the hearing, but they should be requested as early as possible. If you have already submitted documents, the hearing officer will have those. However, if you have additional documents that you want to submit, follow the instructions for submitting exhibits. You may do so within 14 days of receiving the notice. Once your file is transferred to the UCRC, they will schedule your hearing and you will receive another notice with the date and time of the hearing and a telephone number to call into. Do not miss your hearing, as there are only very limited reasons they will excuse your failure to attend. Although you may request to hold the hearing in person, this is generally not done unless there is an important reason. For example, if your case depends on a video or a visual exhibit that all the parties should be together to view. On the day of the hearing, you will call in 15 minutes early to provide your name and number. Once the hearing officer is ready to begin, she will call you and the other parties and place you into a conference call. The hearing will be scheduled for 45 minutes, and the hearing officer will do what she can to get it completed within that time. However, if it needs to, they may schedule it for a second hearing day. The hearing officer will begin the hearing with a brief introduction. If you have been terminated, in most cases, the hearing officer will start with the employer's witnesses, asking them questions based on what she already sees in the file. If you resign, the hearing officer will start with you instead. Witnesses will then be given the opportunity to add more, and the other side will be given the opportunity to cross-examine them. At the end of the hearing, each party will be given a brief amount of time, about 2 minutes, to give a closing statement summarizing their position. You will not receive a decision on the day of the hearing. In most cases, we find the decisions come within about a week after, although it's not unusual for it to take a few weeks. Savinsky Law Offices prides itself by the preparation it does before hearings, as well as representation during the hearings. By becoming fully prepared for the hearing and focusing on the most important issues, you will find yourself comfortable and able to have your case presented in a compelling manner that will increase your likelihood of success. The unemployment appeal attorneys at Savinsky Law Offices provide personalized representation, valued for their experience and respected for their skills. If you have found your unemployment compensation denied, re-empower yourself by contacting Savinsky Law Offices for a free telephone conversation at 800-641-1970.